All right, what's up, everybody? How's it going? You hear what's Erica Kelly? We'll clock this T. And in today's reaction is gonna be on Yella Beezy. Okay, the rapper Yella Beezy has a $2 million murder for hire bond on the rapper Mo 3. And his bond has got reduced to $750,000. Okay, let's see what's going on here. Make sure y'all hit that like button for your girl. Okay, Yella Beezy. He's a rapper. He goes by Marcus Conway. He appeared in court on a bond reduction hearing. His bond amount was $2 million after he was arrested last week for the death of rapper Mo 3, Melvin Noble. Prosecutors showed a video of the man shooting and chasing down Mobile in the middle of the street on I-35W in his car on a freeway. Let's take a...
Finding an RV rental shouldn't feel like a puzzle.
Man, go ahead and hit
Meet
that like
outdoors,
button for your
where
girl.
you can choose the right RV for your next trip. In between. Outdoors. 44,000 ways to make your sit at home. Anywhere. Get a rental starting at $99.
Just for context, this is
All right, let's analyze.
I-35 heading northbound.
Let's analyze this real quick.
Kroger 18-wheeler, and this is heading north I-35 into downtown Dallas on November 11th, 2020.
Oh yeah, see them cars? Yeah, that car was chasing them. Hell no.
Now, Your Honor, if I could draw the court's attention, if you look on I've stopped this video at 19 seconds. You see a gold sedan in the far left lane and a black sedan in the second lane to the left. The gold sedan will be the vehicle carrying the victim, and the black sedan is the vehicle driven by Q1 White, who is then the shooter, based off of the evidence we have.
On his ass. Now, supposedly, Yella Beezy paid $40,000. I don't know why he stopped the car. Why he stopped like that? Okay, going around. Oh, the heater's not there. Oh, look at him. He on his ass. Oh shit! He tried to run. He should have stayed in the damn car. And then you got out the car, dog, and walked around to the glove department. Why you didn't look in the glove department while you was in the car? Yeah, he had to do the job. His job was done. 40,000. Got away in broad daylight. Wow.
Your Honor, I'm going to stop this at 1.
Shit, for 40,000, shit, I'll get somebody for 40 grand. Now, 44 bullet casings were prosecutors told Judge
Costco is the best place ever. I went so high.
44 sideway bullet casings. Now, prosecutors told Judge Gracie is that the state was part of the conversation about the payment for Noble's murder. How did you draw $40,000? Like the day after Mo3's murder. That state's witness will also testify that Yella Beezy was one of the individuals responsible for a portion of that payment. The state argued that Beezy is a danger and has the means to flee if he wants to. He got all that money. I would have been left. The fuck? As soon as he would have hired, I would have moved. Adams also argued that the rapper drives a bulletproof denial for a reason, according to 2020 bank records. Had $870,000 in his checking account and savings in one bank. Damn. $870,000? Man, they be giving the niggas weirdest money, boy. They be giving the wrong niggas money, dog. The judge also listed testimony from the rapper's grandmother, who said she could not afford to pay a $2 million bond despite owning a bulletproof denial and living in a mansion in Frisco. Oh, he got grandma in a mansion? He got grandma in a bulletproof car? He might used to be, but he could make a $2 million bond. He'd be out. Defense attorneys told Judge Lewis that the state had not connected their client to any murder for hire. You've received no information of a text message. Any message on social media platform that client paid for this murder for hire, any type of remuneration, just this person who came forward and said he overheard this conversation. Now, Judge Lewis ultimately decided to reduce Conway's bond amount to $750,000 with conditions, including an order against contacting any of the victim's witnesses. You are to have no contact, direct or indirect, or threatening or harassment of any victims or witnesses. If it's you or anybody on your behalf, there's going to be a problem. Do you understand that? Understand the folks that? She said. She also reprimanded Yella Beezy to seemingly not taking the case seriously. The financial statement that the defendant was to put on file, he didn't seem to take that very seriously at all. And that causes me concern about whether or not he's taking seriously allegations against him, Judge Lewis said. Now, he was arrested and was charged with capital murder. Let's see the arrest video when he got arrested.
Sky Zone is the best place ever. I went so high, I think I touched the sky. Mom, did you?
Hi, good evening, everybody. I'm Steve Veiger. Dallas rapper Marquise Conway, who goes by the name Yella Beezy, was arrested and charged for a murder for hire scheme. He was arrested earlier this week, connected to the 2020 murder of another rapper. Fox 4's Stephen Dahl is in the newsroom with more. Stephen.
Steve, the murder victim back in 2020 was Melvin Noble, who went by Mo3. Noble was killed in an ambush-style shooting during the day while he was on I-35 in Dallas. Investigators identified Kewan Dontrell White as the shooter in that crime. White is currently serving 9 years in prison for a firearm charge connected to the shooting. Conway, who goes by Yella Beezy, is accused of hiring White to kill Noble.
All right, Steve, what's the backstory on this? What are prosecutors saying about a motive for this hit on Noble?
Yeah, so we've requested court documents outlining the claims by investigators to arrest Conway. We usually are able to get an arrest warrant affidavit. That's where we get a summary of the evidence in the case, but because this case was a grand jury referral, We don't have access to that information. So exactly how Conway is linked to the murder for hire plot is unknown, but it was strong enough information for the grand jury.
Got it. So the murder or hit was almost 5 years ago. What's Conway's current status?
So at last check, jail records show that Conway is still in jail being held on a $2 million bond. If he is able to bond out, there's a list of things that he would have to abide by to be in those rules and regulations until his court appearance.
Got it. Okay. All right, Stephen Dow in the newsroom. Thank you, Stephen.
Hey, play for an ultra?
Racing for an ultra?
Don't forget, there's ultras on the line.
Woo!
I didn't.
Michelob Ultra, superior like this.
All right, now to a developing story. North Texas rapper Yella Beezy in court today accused of killing another rapper. Our Natalie Haddad joins us live now from the courthouse in Dallas. Natalie, a lot of people interested in this story. What happened in court today?
Yeah, absolutely, Janelle. I was sitting in the hearing in that courtroom and every seat was full, every pew, I should say. And again, just mentioned, we just walked out of that courtroom. A judge granted rapper Yella Beezy a lesser bond. This was his first court appearance. It was all about the bond that he was assigned to him when he was first arrested. Now, Yella Beezy, whose real name is Marquise Conway, he was arrested just last week in a murder for hire plot. So some background for you. Conway was initially given a $2 million bond. His defense team argued he could not afford that and he needed to be in a position where he could continue to provide for his immediate and extended family. And despite the prosecution arguing that Conway could pay a $2 million bond if he wanted to because he lives in a mansion in Frisco and flies in private jets, Conway now returns to jail with a $750,000 bond instead. So it went from $2 million to $750,000. Conway arrested last week, nearly 5 years after the murder of another Dallas rapper, Melvin Noble, known by his rap name MO3. Conway is accused of hiring a hitman who carried out Noble's murder. He faces a capital murder while remuneration charge, and this means that the killing was done for financial gain or reward. Now, back in November of 2020, Noble was shot and killed on I-35 in Dallas. I believe we have seen video of that. He tried to get out of his car and run, but was gunned down by a man with a rifle. 2 men were arrested in the weeks following his murder and are facing federal charges themselves. But now this case against Conway could reveal details into the hired hitman's payment and the motivation behind the murder. Again, just walked out of the courtroom just a few moments ago. Conway was escorted back to the jail. He was present for the hearing. So we will keep you updated right here on WFAA whether Conway pays that now $750,000 bond. Janelle?
Woo! Thanks for that update, Natalie.
ABA therapy uses the science of learning.
Do y'all think he paid that $750,000 bond? I want to see that little court clip when he was in court. Let's get into this.
Are we ready to proceed?
Yes, Your Honor.
Yes, Your Honor. You want me to talk to Mrs. Klein?
We've already talked to him.
Great. Sir, if you'll stand for a second. This is cause number F2500154, Style of the State of Texas versus, is it Marquise Conway?
Marquise Conway.
Okay, Marquise Conway. Mr. Conway, you are here charged with the offense of capital murder while remuneration. This offense is a capital felony. You talked to your attorney about what's happening here today.
Yes, ma'am.
This case is set for a bond reduction hearing. What is the current bond, or is there a current bond?
Current bond set at $2 million, Your Honor.
Okay, all right. And your attorneys are here today asking the court to reduce your bond. You understand that's what this hearing is about?
Yes,
Okay, all right, have a seat. Is the state ready to proceed?
The state's ready, Your Honor.
State may proceed.
Your Honor, at this time, the state would offer into evidence for the purposes of this hearing, State's Exhibit number 1, which is the PC or probable cause affidavit for Kewan White. That's K-E-W-O-N, White, common spelling. State's Exhibit number 2, for purposes of this hearing, would be the probable cause affidavit for Devin Brown. State's exhibit number 3 is going to be a video of the offense. State's exhibit number 4 are going to be the bond conditions that were placed on the defendant, in this case on March 21st of 2025. State's exhibit number 5 is going to be the PSA weighted scale score that was given by Dallas County Pretrial Services on March 25th of 2025. And then state's exhibit number 6 will be the financial, confidential affidavit of financial condition that was filled out by the defendant. That's state's exhibit number 6.
No objection, Your Honor.
State's exhibit 1 through 6 are admitted.
And we'd ask the court to take just judicial notice of the probable cause affidavits and having been able to review them prior to this proffer.
So noted.
Thank you, Your Honor. Based off of an agreement with defense for the purposes of this hearing, I will also proffer the following information. To start, before I forget, the state did run a complete criminal history of the defendant, including both juvenile, misdemeanor, and felony criminal history. That information was ran yesterday. The court may notice that in state's exhibit number 5, the PSA from Dallas County Pretrial Services, that there is an affirmative when asked about prior convictions. I believe it specifically mentions felonies. I will represent to the court based off of all the information and reviewing all of the evidence that we have at this time. The state can find no prior misdemeanor convictions or prior felony convictions for the defendant, either as a juvenile or as an adult in the state system or the federal system. We had also proffer the following information, Your Honor. A state's witness will testify to being present for a conversation about the payment for the murder of Melvin Noble. This conversation took place in the days following Mr. Noble's murder in November of 2020. A state's witness will testify to the individuals present and involved in this conversation. The state's witness will also testify to Marquise Conway, the defendant, being present and involved in this conversation. The state's witness will testify to the amount of money that was to be paid for the murder. A state's witness will testify to the individuals responsible for the payment. That state's witness will also testify that Marquise Conway was one of the individuals responsible for a portion of that payment. A state's witness will also testify to the individual who would receive this payment. The state's witness will testify that Kewan White was, in fact, the individual to receive this payment, who was originally indicted in state's exhibit number 1, the probable cause, which is before this court. The state's witness would also testify that Kewan White, or to who shot and killed Melvin Noble. This witness would also testify to Kewan White being the individual who shot and killed Mr. Noble on November 11th of 2020. Again, this conversation took place in the days following Mr. Noble's murder. The state has also had an opportunity to review bank records of the defendant, Marquise Conway. These records would show that the defendant drew $40,000 in the days following the murder of Melvin Noble. And for the record, that was a cash withdrawal. These records would correspond to the exact amount which the state's witness would testify to. In reviewing these records, the state also became aware and believed that they would show that the defendant had anywhere between $800 and $900, but more specifically $870,000 between a checking account and a savings account with one particular bank. 370 of which was in a checking account, a little over 500,000 which was in a savings account. The state at this time would like to publish to the court what's been marked as State's Exhibit number 3, which is the video of the offense. Thank you, Your Honor.
Now, before that's published, could I just address something with the prosecutor and the proffer? Sure. So it's clear for the record that as he recited, the state's witness, his proffer is, that's just one witness.
Correct, Your Honor.
Multiple witnesses. And that I don't recall if the specific in the proffer was when the date that this witness reported to hear this conversation.
I do not have the specific date written down, but I know it was in the days following the offense. We do have evidence of when this could have taken place based off of cell phone data of when the defendant was in another state and then when he came back to Texas. So we believe we have a time frame. As far as the exact date, I do not have it this time.
Anything else, Mr. Smith?
No, Your Honor. Permission to publish, Your Honor.
Yes. Y'all want the lights off?
It's at the court's discretion.
Oh.
And Your Honor, this is
His grandmother?
Miss Alexander, are you currently employed?
No, I retired from Dallas County in 2014.
Now, when you tell the judge you retired from Dallas County in 2014, what was your occupation?
Deputy clerk.
And just for the record, a deputy clerk, what does a deputy clerk do?
Process paperwork from the attorneys for the judge. Basically handle the paperwork for the courts.
And this is a building that you were employed, is that correct?
Yes, it is.
And back in the clerk's room, where in the old days, we had a lot of paperwork. Lawyers would take the file, take it back to the clerk. You would handle the file stamps and put all the papers into the file.
And type up the judgments.
Type up the judgments. Can we back up a little bit? Just tell the judge a little bit about where were you born and when did you move to Dallas County?
I was born in Washington, Arkansas. I moved to Dallas County when I was 11. So I've been here like 63 years.
And being Marquise's grandmother, could you explain the dynamics of your family as far as where are they located and how many grandchildren do you have and where does Marquise fall in the family relationship?
Okay, Marquise was my first grandson, first grandchild. I have 11 grandchildren and 8 great-grands. Of course, Marquise being the first grandchild, we were always close because you're excited with your first grandchild. So you try to do everything you can and instill in them good values. He's been a godsend to a lot of his family members. He helps everybody in the family. I know it's hard sometimes because when you have people pulling on you and you just trying to stretch money, you know, it doesn't always pan out. But he's always helped whenever needed. He's just been.
Let me interrupt you just a minute. When you say, let's just go back a little bit. Did he go to public schools here in Dallas County?
Yes, he did.
Was he born and raised here in Dallas County?
Yes, yes, he was.
And does he currently work here in Dallas County?
Yes, he's an entertainer.
Okay, and as an entertainer, so we can explain to the court, what type of entertainment does he do?
Music.
And has he done well in his music career?
Yes.
And in the music career, you have a persona, is that correct?
Yes.
Okay. And it's a persona out there for your career is different within the family fold, is that right?
Right.
Him being your grandson, did he go to church here in Dallas County?
Yes, he went to church with me often. That was one of my requirements when he'd spend the weekend.
And how often do you talk and have a relationship with Marquise?
When he's in town, 2 or 3 times a week. When he's out of town, sometime once a week.
His His relatives, are they here in the courtroom today?
Yes.
And is his mother back there in the courtroom?
Yes, she is.
Okay, and for the record, could you just tell is that Miss Kimberly Rush?
Right.
Is his family here? Are they all here in Dallas County or Dallas-Fort Worth Metroplex?
Vicinity, yes.
Are you here to just tell the judge he has sufficient ties to this community?
Yes, he does. He does.
Now, as far as, does he have any children?
Yes, he has 2 sons,
And how old are his children?
5 and 7.
Is he, have you observed him being involved in his children's life?
Yeah, we go to football games for the little ones all the time. He's always got them in sports.
Okay, so he's out there in the community, coaching up his sons and other kids that play on the football team.
Yeah, I call him the Joe Jackson of the sports.
You call Joe Jackson being Marquise?
Yeah. Joe Jackson was Michael Jackson's father. You know how he pushed them to be great and good. So I said that's what he's trying to do with his boys.
I'm glad you cleared that up. There's other Joe Jacksons, but yes, I can get that Joe Jackson would be well involved in his family.
Yeah.
So you're telling the judge he's from Dallas County, significant ties, and he's involved with his family. As far as you're aware that he is been arrested for this charge.
Yes.
Of payment for hire for a murder. And this happened back in 2020. You're aware, you saw the video and you heard the prosecutor talk about
Yeah, on Facebook.
Their version of the facts.
Right.
How long has he been in jail?
Oh, 8 days since last Thursday.
The bond set at $2 million. Has he been able to post that bond and get out of jail?
He's still sitting here. No, he hasn't.
We're asking the court for a $250,000 bond based on, do you believe that Mr. Conway could post a $250,000 bond?
I'm pretty sure we can get it together.
And are you telling this court that he's not able to post a $2 million bond?
No, he's not.
That's witness.
Cross-examination.
Yes, Your Honor. Good morning, Ms. Alexander.
Good morning.
My name is Tommy Adams. If you have any questions with my questions, if I don't form them in a good way, please just ask me to repeat myself and I will do so, okay?
Okay.
I appreciate you being down here. I'm sure this is not an easy day for you. So thank you. You worked for the Dallas County within the clerk's office up until 2014, correct?
Correct.
Now, Ms. Alexander, are you aware that there was a bond schedule that judges could set bonds on different level offenses within this courthouse?
Yes.
And are you aware that that bond schedule has since been done away with and was subject to a federal lawsuit against all of the district judges within Dallas County?
No.
Now, when you talk about your grandson being an entertainer, I mean, he's more than just an entertainer, correct?
Yes.
He's in fact a double platinum artist, correct?
Right.
Now, going back to 2020 and the years leading up to that, well, let me ask you this. Are you aware of your grandson owning a 2017 Denali?
Yes.
And what is that Denali, what is special about that Denali?
It's bulletproof.
It's bulletproof. Now, Ms. Alexander, I can't imagine in all your years working here at the clerk's office that you ever felt like you needed a bulletproof vehicle.
I don't need one.
Now, Ms. Alexander, would you agree with me that in 2020 and the years leading up to 2020, that there was a lot of stuff going on in the city of Dallas surrounding, and to be quite honest, our victim, Melvin Noble, and your grandson, Marquise Conway?
I try not to delve into Facebook and hearsay because I know him for myself. So.
Well, let me ask you this way. Are you aware your grandson was shot in Plano?
Yeah, I was there.
You weren't there at 3 a.m., were you?
I was at the hospital.
Correct. Okay.
Mhm.
But you would agree with me that even if you're not on Facebook, I mean, this stuff was on TMZ. I think your grandson even did an interview on TMZ with those folks on live TV about this. So you're aware that there was a back and forth going on in this city involving your grandson as well as Mr. Noble, the complainant in this capital murder case. You're aware of that at least, right?
Yes, somewhat.
Is that the reason your grandson felt the need to get a bulletproof Denali?
No, he felt the need because people are jealous and you don't know who's gonna do what, when or where.
Now, are you aware of whether or not he had to, if a Denali comes that way off the lot, or do you have to actually pay money to get something like that done?
I have no idea how it happened, where it happened, why it happened. I just know he had it.
Sure. And as far as your grandson being in custody for approximately 8 days, defense asked you initially how long he'd been in jail and if he was able to make a $2 million bond. And your initial answer was, no, he hasn't. And then when they followed up with whether or not he can make a $2 million bond, that's when you said, no, he cannot, correct?
Right.
Now, especially with all of your experience here in the county and working in the clerk's office, you're aware that when somebody has a $2 million bond, they can pay only 10% of that, correct?
Yes.
With the bondsman's help. Now, your grandson is a double platinum recording artist, correct?
Correct.
And he lives in a mansion in Frisco, correct?
Correct.
And he has houses in other states, correct?
And I'm not aware of that.
Are you aware of him paying and helping to support other individuals in the family and also extended family and friends?
I'm not into his business like that.
You agree with me that your grandson is substantially well off, correct?
He might used to be, but if he could make a $2 million bond, he'd be out.
Would you agree with me, though, that there's a difference between can, want to, and choosing not to?
I'm aware of all of those things, but I know he don't want to be in here, so I know if he could afford it, he'd be out. Plus, he has other bills. He don't just have money laying around.
Sure. Now, Ms. Alexander, you testified that your grandson has significant ties to this community, correct?
Yes.
Born and raised in the greater Dallas area.
Correct.
As far as how much time he spends in the city of Dallas, or more or less Dallas County and the surrounding areas at this point, do you know approximately how much time he spends in the greater Dallas area per month?
I'd say 3/4 of the time.
3/4 of the time. Now, just as far as his ability to travel and nature of that, like planes and getting around, you're aware that he travels quite a bit via private jet, commercial, all of that, correct?
Yes.
Does he have access to his own private jet?
No.
Do you know approximately how often he does fly private?
No, I don't.
But when he does that, he would be having to pay for those bills as well, correct?
Correct.
Do you agree with me that flying private is not the cheapest thing in the world to do?
Yes.
Nothing further from State Law.
Anything else from Ms. Gibbons?
No further questions, Your Honor.
All right, thank you, ma'am. You can step down. You have another witness?
Judge, I was gonna make the proffer we discussed, back in Chambers. May I make a proffer, Your Honor?
Yes.
Judge, a lot of us have been down here at this courthouse for 30 years. I'm not gonna go over the law. I know you understand, the bail bond and how we have new law. I just wanted to point out in some of these cases where there's high profile, in the state versus Michael Lucky, that was a capital murder case. That was in criminal district court number 7, the court that we're in. That was a high profile case. That case involved an NBA player that was initially set by the magistrate in the jail with a probable cause affidavit, where they had knowledge of the facts from what the police said. And that bond was originally set at $500,000. It was later reduced by the court to $100,000 with conditions. Co-defendant in that case, Larry Jenkins, cause number F2076397. This is the same set of facts case where the magistrate with a probable cause affidavit set it for $750,000. Another case in the state of Texas versus Antoine Franklin, capital murder case, 522-76141. This involved a famous football player out of Oklahoma. That case was set by the magistrate for $500,000. Again, probable cause affidavit. He was later reduced by the court to $200,000. Judge, in dealing with the bond schedule, you have bond conditions here that require electronic monitor. They have several conditions of probation, check-in, and curfews. We're proffering to the court here that the court has set bonds down here in Dallas County where the typical murders range between $150,000 and $200,000, and a capital murder can range, in these cases, in between $500,000 and $750,000, where the magistrate set them. The thing in this case that we're proffering, the magistrate had no probable cause affidavit. They had no facts. And in this case, we're asking the bond to be reduced in these facts. We'll argue here, but I just want to proffer those 3 cases.
All right, anything else?
We're closed and then we'd just like to argue.
Okay, State.
Your Honor, I would just, if I could, just briefly, I would also like to proffer just 2 cases since defense has brought up some cases that have come here from Dallas County. The first one I would like to bring up is F2475475. Defendant's name is Chaz Booth out of the 194th Judicial District Court. He's currently sitting in jail on a capital murder charge for $2 million. That defendant is not a celebrity, a basketball player, a football player, a musician, an artist, or anything like that.
Okay, what's the bond on that one?
$2 million.
Oh, $2 million.
He is a 20-year-old who is charged with capital murder. Additionally, we have Jordan Owens, who was recently sentenced F2377243, also a capital murder, and his bond was set at $1.5 million, and I believe that was in the 282nd Judicial District Court. And that's, as far as cases, I'm not going to keep going with. I'm not going to go back and forth. So that's all we have as far as rebuttal.
Your arguments?
We'll wait and reserve the right for rebuttal.
All right.
Judge, I'll begin and then Mr. Kuski will finish up with our. Your Honor, as you know, under 1715, the court considers certain facts in the bond reduction hearing and determining whether to reduce the bond. Here in this hearing, the court has before you been introduced 2 arrest affidavits. There is not the arrest affidavit of our client, that does not exist, but you do and have reviewed the arrest affidavits of Kewan White and Mr. Brown. Those arrest affidavits were taken on Kewan White was December 8, 2020, Devin Brown, March 18th of 2021. Now, the offense itself is approximately 4 years and 4 months ago when it occurred. You carefully reviewed those affidavits and set out how the offense, and you saw the video. Nowhere in those affidavits is there any mention of our client, any mention of his role, any mention of connection to this case in either one of those affidavits that you have before you that you can consider. As far as the proffer given by the state, they choose what they can proffer. They said they have one person who overheard a conversation after the incident that happened on the highway in which he heard money being discussed and our client present at that during that conversation about paying money. You received no information in the proffer as to the credibility of that witness, if they have a bias or a motive for coming forward now at this time, 4 years, 4 months later, with this information. You only have you don't even have a proffer that this was a confidential informant, which you know requires some type of vetting, just that it's a person who said they were present during this one conversation. And that's the only evidence that you have before you this hearing that connects into this offense. The state also proffered a bank record that said there was after the incident in November of 2020, there was a withdrawal of $40,000 cash. No proffer was made as to if that money, if there was traced anywhere to the other defendants charged in this offense. You've received no information of a text message, any message on social media platform that our client paid for this murder, any type of remuneration, no recording of any sort, just this person who came forward and said he overheard this conversation. As far as the bank records go, the only thing in evidence before the court are records that were back in 2020 when they quoted 2 different accounts which accounted for $800,000. You've heard no evidence as to his current financial bank records and what is in there. You only have before you testimony of the defendant's grandmother who told you he cannot make the bond, has not been able to make the bond, he cannot make the $2 million bond. I'll let Mr. Beezy finish with the other parts of the argument.
Judge, thank you. I'm not going to go back over what Mr. Shook said. What the court has before you is a case that's been investigated for 5 years, and my client, Conway, is a citizen of this community that has no flight issues. He has not left this community. He stays in this community. His family is sitting right back here in the courtroom that showed up to the support in this community. A big factor of this is that he has significant ties to this community. The current bond conditions that you have in place with a leg monitor would be whatever concerns that the state may have or the court may have to know where he is. His grandmother has worked down here and understands how to communicate with the court. We have people and the bond restrictions of that. The court is aware of how significant the bond restrictions are in keeping them and writing a bond. Judge, we're coming at this this is a significant oppressive and punitive bond and under the law in our opinion. We believe that the magistrate, when she set this bond, did not have any evidence in front of her and set it high. We also believe that after 8 days, had he had the money, he would have posted it, and he's sitting here in jail. And that those cases that the state and I have talked about, the court is well aware of a wide range that you have, but given these facts that Mr. Shook went over with no corroboration, we don't know anything about their case, this witness, who they are, the court doesn't. And given the facts presented, we're asking you to reduce this bond to an appropriate amount where he can abide by the conditions and come to court and we can fight this case.
Okay, thank you. State?
Yes, Your Honor, just briefly. In regards to an individual's ability to pay the bond, Ms. Alexander testified specifically that she is not involved in her grandson's business and doesn't keep up with his financial stuff. So she really was not in a position to testify what he can and what he cannot afford. She did testify to the fact that he is a double platinum, I believe as of recently 2 weeks ago, recording artist, that he travels about a quarter of the month, that he lives in a mansion in Frisco, that he drives a Denali, a bulletproof Denali, which also will lead into safety concerns. So the only thing that the court has as far as ability to pay or not to do it, or not having an ability to pay this bond, is the bank records which I proffered to the court. Successful artist living in a mansion up in Frisco that flies on private jets and travels. The important thing about the Denali is not just the fact of the cost and all that, but it's the fact that when we're talking about safety concerns for the community, one of the factors that the court should take into consideration is, if this individual were to get out, is there a viable safety concern? The fact that the defendant has a bulletproof vehicle and drove one at the time and was arrested in it 8 days ago, that should tell you all you need to know. And that's not just based off of pure jealousy. Your Honor has been doing this long enough to know that is based off of something much greater than just pure jealousy. As far as safety circumstances for the community, this is, as defense has stated, a very high profile case. And this defendant is very well known, not only locally, not only in the state, but nationally and internationally. The fact that this individual has the means and the resources and the reach to get to witnesses is a true concern that the court should also take into consideration. And that this was part of a bigger thing that was going on in 2016, 17, 18, 19, 20, culminating in the death of Melvin Noble. The circumstances surrounding are not only the offense in itself, but the circumstances building up to Mr. Noble's death. And Your Honor, I didn't want to go back and forth with the defense on proffering cases of bonds and $2 million and $3 million bonds. But the truth is, this is a capital murder for remuneration. And the defendant is charged with paying other individuals to take another human life. And he has the financial means and the reach to do it. In fact, I think it's important that there was another victim. This was at noon on I-35 leading into downtown Dallas. 44 fired cartridge casings. Who knows how many others were knocked away by the cars that kept driving by. Melvin Noble was hunted down on November 11th in 2020, a beloved son of Dallas. It could have been so much worse, and that's a terrible thing to say when it's a capital murder for remuneration, where he has paid another man to hunt down and kill somebody in broad daylight. Your Honor, based off of all the testimony and the facts that have been presented in this court, we'd ask that you leave the bond where it is at, currently at $2 million.
All right, let me have the exhibits, and then if you all will give me about 10 minutes, I'll respond.
Got it, Your Honor.
Yes. The defense did not have any exhibits, right?
No, Your Honor.
And this is just the video, right?
Yes, sir.
Anything else that I need to take with me?
And you had 1 and 2 still.
Yeah, I said that.
Thank you.
All right. Okay, the court, is the court ready?
Yes, Judge.
All right, the court's ready to make my ruling. The court is going to reduce the bond to $750,000. The court took into consideration, certainly the biggest consideration was the offense, the severity of this particular offense. It's pretty egregious to watch that video. But the court also took into consideration the evidence or lack of evidence that the state presented. That was a factor also. Another concern I had was the financial statement that the defendant was to put on file. He didn't seem to take that very seriously at all. And that causes me concern about whether or not he's taking seriously the allegations against him. So I am going to set the bond at $750,000 with the bond conditions that were already set. But included on that, I want it to be very clear, Mr. Conway, that you are to have no contact, direct or indirect, no threatening or harassment of any victim, witness, co-defendant. If it's you or anybody on your behalf, there's going to be a problem. Do you understand that?
That's right.
Okay, you all can stand. I'm talking to you now. So that's going to be a concern. And then I want to make sure that you provide the court with correct information regarding your person of contact, because basically this affidavit seemed to be your way of saying, forget y'all. I don't want you to open your mouth. Yeah. Seemed to be your way of saying, forget y'all. So you need to provide correct, accurate information regarding who is your person of contact should there be any type of problem. I hope that you're taking this seriously because your responses in this affidavit kind of indicate that you're not. You understand me?
Yes, ma'am.
Okay. Is there anything else?
No, you're going to say, Your Honor.
Anything else from the defense?
No, Your Honor.
All right. Thank you.
Thank you, Judge.